it's Acacia, the CEO Legal Coach. Today's topic is non-disclosures versus non-competes for small and medium business owners. This is one of those areas that I've noticed a lot of clients have been taking like an all or nothing approach based on some of the news out of the FTC earlier this year. But that's actually not what is going on. So let's take a deeper look into what each of these things are, when each of them is illegal to use or can put you into a little bit of legal waters versus when they are meant to be there. When are they the best tool for you to use and how to use it? So that is today's topic. And as always, there is going to be a live Q&A at the end, as well as a freebie for everyone to have. So let's go ahead and kind of take a quick look at the action headed your way in today's short but effective talk. We're going to look at what is a non-disclosure agreement and a non-compete. When do you use them? Why do they exist? And then realizing that they're not always on separate paper. And I think that this is one of the reasons, there's more than one coming up, one of the reasons business owners get confused is they think that because one is on the paper, therefore the other one is also part of it. Not the case, and we'll look into that. Also, there's different legalities when using each one, whether or not they are together or separate. So it's important to understand those dynamics as well. So let's get in there. And in case you are not familiar with who I am, my name is Acacia Thornton. I'm the CEO Legal Coach, longtime corporate attorney, turned business coach, but also a longtime small business consultant. And so I am here to make sure that small business owners are protecting their information from day one, because you are very, very at risk if you're not, but that also shouldn't rely on you making millions or having millions in the bank in order to do so. So that's what I'm here to do. And that is why today's information is really important, because it gets at the crux of protecting your information, your business, and making sure you actually have a tomorrow, right? Because if somebody comes along and steals or misuses your information, shares it with the wrong person at the wrong time, that could be really, really impactful in a way that could put you out of business overnight. And yet, you wouldn't have any choices unless you're using the documents we're talking about today, which is why it's really important to make sure we're using them at the right time. Now, one of the documents, if you know anything about me, I am really big into the non-disclosure agreement. What is a non-disclosure agreement? A non-disclosure agreement, sometimes called an NDA for short, it's a document, it's an agreement between two or more people, usually two people or two companies, that says, hey, you might have access to or receive or need to use some of the information from my company in order for us to do business together, right? That's really common with a customer. You might have to go give demos, share pricing sheets, or to work with a supplier. You might have to show them how you do business or send them some of the information for them to put into their software or to their systems. But this also happens when you're trying to get investors. You got to share information that is not available to the public. That is the crux of your business, that if somebody took it and misused it or gave it to the wrong person or decided to sell it, well, that's harmful to you. So the non-disclosure agreement is the agreement that says, if you get any information to me that falls within this definition of confidential information, you are not allowed to disclose it or share it. That's where the word non-disclosure comes from. You can't disclose that to any third party, and you can only use the information I'm giving you for the purpose and reason I'm giving it to you. So that's what's really key about these, and why non-disclosure agreements are important from day one for every company, because if you don't have that information protected underneath a contract, guess what? It's not protected. With a few exceptions for intellectual property, that's it. You've given away your information, and it can be misused and abused and shared. So non-disclosure agreements are imperative to control the flow of your information, control the flow of who has access to, when, and how it gets used, right? That's your information. You're disclosing it for a reason, and that's not any reason. So now let's take a look at a non-compete, right? We talked about how a non-disclosure agreement is about not disclosing. A non-compete agreement is about not competing with you. And these get used in business context as well. And we can use them, same with a customer, with a supplier, with our partners, with our investors, as well as our employees. NDAs are used in the employee context as well, right? Because employees have access to your confidential information. But in the non-compete aspect, the non-compete is saying, hey, you can't go work with my competitors. You can't go have one of my competitors as your client. You can't have one of my competitors as your supplier. You can't go work for one of my competitors. And that's a different context than not sharing information, right? So non-compete, they come out the most often in a freelancer situation or an employee situation, because those are people who understand how your business works in the day-to-day. They see things a little bit differently. And if they were to just get up and now the next day go work for your direct competitor, well, they're walking out the door knowing how you do business, how you do things, and the information, the know-how, your workflows, things that are a little bit different. And so the non-compete is about not going to a competitor. Now, let's take a look at when these documents start to overlap, because it is absolutely possible to have a non-disclosure agreement with a non-compete section in it. And it is possible to have a non-compete with a non-disclosure section in it, right? So the non-disclosure is you can't take the information, share it, or misuse it. The non-compete is you can't go work for or have as part of your immediate circle one of my competitors. And this is where we start to get into the needing to understand when one is the right way to proceed. Okay. A non-disclosure agreement is imperative in business from day one, no matter what type of company you have, no matter who you're working with, customers, suppliers, vendors, investors, partners. Non-disclosure agreements are imperative because they prevent your information from being disclosed. They prevent that information from going to somebody else. And who is that somebody else? Any third party. That could be a competitor. It could be your mom. It could be them using it. Like if you're going to go get an investor and you're giving a presentation about your investment, about what you want them to invest in your company for, you're basically disclosing to them how to do the business, what the idea is, all those things. But they're the ones with the money, which means they're the ones who can go do it faster. They're the ones who can do it with or without your help. They are the ones who could go hire everybody else to do it for them quickly and faster than you can. The controlling the flow of your information is imperative to any business success, always. Just like when you're working with a customer and you give them hey, here's our packages, here's our pricing. They don't just take that straight out the door to your competitor and be like, hey, so-and-so gave us this at this rate. We want you to meet that, right? They're disclosing your confidential information, provided that information was not already publicly available, like on your website, for example, right? Some companies put their packaging and pricing right on the website where others keep it hidden. So non-disclosures are necessary in business because without it, anyone can take your ideas, anyone can take your information, they could sell it, they could reuse it, they can make their own company, and so on. It's how you keep your information and your ideas yours, no matter who you're talking to. But there have been times where non-disclosures get overly. What is that? Okay, technical difficulties. What happened there? We are here. Not a video. Totally random there. Okay, so non-disclosure agreements, like we just said, necessary, imperative. Your business is at risk every single day, every single conversation you have without one. But there are times they are illegal, right? It is not okay to contract to hide anything illegal, right? It's illegal to hide illegal things. So if you're off committing crimes, whether you're embezzling whether you're stealing somebody else's intellectual property. If you are doing things that are illegal and you're getting somebody to help you, like a freelancer starts to do stuff, or you hire an employee and it's going to be like, hold up, this doesn't feel right. And then after months or years of working with you, they start to sense that something's not right. And they go tell the police, they go tell the agencies or whomever. You can't be like, well, you can't disclose that. You have a non-disclosure agreement. That's what you sign, that you can't share our information, right? You're hiding a crime. And related to that in the employee context is that whistleblower element, right? This comes up a lot in financial crimes and white collar crimes, but is not exclusively limited to that. Employee violations, OSHA, things like that. You can't just say, hey, you have a non-disclosure agreement, therefore you can't go tell or whistleblow on us, especially because there are laws out there where the employee is meant to be incentivized and protected to whistleblow. Because if the people who are seeing the illegal activity can't say anything about it, then it remains hidden. And that is against public policy. That's not something we want to encourage in the world of business or in life in general. So these are things that you can't sit there and be like, hey, we have a non-disclosure agreement. You can't go tell anyone. So your non-disclosure agreement in some states is like invalidated the second that happens. In others, it is likely to be invalidated, or the employee or person, company, whomever it is likely to be given, a green pass, a gold, like all good, cleared. You're not in violation of a non-disclosure agreement, which would be a breach of contract. So you're not in breach of contract because you're doing the right thing by telling us that there is a crime, by whistleblowing as you're supposed to under the laws. The other area where non-disclosure agreements are considered not the greatest and can be invalidated is when they are overly burdensome. This doesn't happen as often in the NDA context, but it does happen in the non-competes a lot, which we'll get to in a moment. But when anything and everything under the sun is protected, where the person can't even have a conversation, or the person can't go have a job interview, or things like that, it becomes overly burdensome. And that is another area where the courts have invalidated them. But the big things when it comes to non-disclosure agreements is that you generally cannot use them to hide any crimes, anything where employees under the law are incentivized to tell the government, like whistleblower situations, and anytime that the non-disclosure agreement becomes overly burdensome, where, as you'll see in our next slides, really can impede the person. And that's going to be one of the biggest differences between non-disclosure agreements and non-competes, is person versus information. So non-competes, right? We just talked about how non-disclosure agreements are about the information, right? When somebody's going to whistleblow on you or tell that you're committing white-collar crimes or saying that you're embezzling, they're not going to your competitors. They're going to the government. They're going to do what they need to do for public policy purposes. A non-compete is necessary in select B2B contexts. Majority of the time, you do not need a non-compete. But they can be necessary in certain B2B contexts. B2B meaning business to business. An example is like a freelancer. You might want to put a non-compete in there, or a particular customer. Kind of think about exclusivity concepts that we have with our customers. That's in a form of a non-compete because they have to use you and you only. With your suppliers, same. So how we phrase and use a non-compete can be a little broad, right? That exclusivity concept. But usually it is something phrased along the lines of, hey, for the next 2 years, you can't go work with any of our competitors. For example, the competitors listed on page 12 of this document, right? And you'll list out the competitors, and then they know that for 2 years, they can't go work with them. That restricts business decisions. It restricts business flow. Now, that is one thing in a competitor situation when you're working with a customer or supplier. As an employee, This is where non-competes got a blanket illegal to use them by the FTC earlier this year. It is illegal to use a non-compete in the employee context. Why? Because when we are restricting an employee from going to a competitor, we are restricting their ability to get another job. Whenever we leave a company or we stop working with somebody, we all have some level of expertise or experience working in that industry. And so you can't change industries or change an entire job or career every time you want to leave a company. That becomes overly burdensome. And depending on where you are geographically, there might only be one other company in a 100-mile radius that you could even go work for. And so when they say you can't go do something, you can't go do that for 2 years, guess what? You're basically saying if you leave us, you're unemployed for 2 years. And that is a different concept than saying you can't take my information. And so that is why the FTC banned non-competes in the employee context. You can't restrict an employee's ability to go get another job just because you have competitors. Every business has competitors. Everybody has competition out there in one form or another. It's not fair to the individual, to the purpose. I have been restricted from getting jobs. My family has been restricted from going to jobs. I have friends that have sat there and literally gone to other boring, lame, low-paying jobs for 2 years just to wait out their non-competes. Non-competes are impacting people's ability for a livelihood, people's ability to be personally involved and have value in what they bring to the world. That is why the FTC banned non-competes in the employee context. Now, there is a minor exception to that illegality that the FTC said. There are certain high-level employees, usually director or level or higher, depending on how your company is structured, where you can still use a non-compete, provided those non-competes still need to be narrow. When it comes to your competitors, it's one thing to say you can't work for any of our competitors for 2 years. Okay, that's really broad. Any competitor, anywhere, in anything they do, versus, hey, you can't go work for a competitor's division that has a competing product and is within 30 miles of your house. And that is for 6 months. Okay, that's a lot more narrow, right? It's only 6 months. It's within 30-mile radius, and you can't work for their competing product is different than not being able to work for the competitor. The more narrow it is, the more likely it is to be legal, right? Not being part of something for 6 months or a year, you usually lose what's going on over there because most business plans and actions, they're rolled out pretty quickly, usually in a quarter or two, and not too many 5-year plans. Things change over the term of time. So when you do have those minor exceptions, you do want to be mindful that you have strongly narrowed and tailored what you need, right? It's one thing to list, hey, from these 3 competitors versus nobody in the industry. The more specific you can get, the better. The other thing is you actually have to have a business reason why. There has to be something you can explain to the court. I needed this to protect my company. Hey, this company and I are both building competing products right now. We're rolling ours out in the next 6 months. This employee had direct access to all of that information, knows how we're going to roll it out, knows all of these things. I can't have him go take that to the other company right now, right? That's a very legitimate business reason versus being like, well, they're our competitor. Not every company competes one-to-one literally all the time and forever. So these types of considerations are important, but the FTC did say that you can have a non-compete with your employees, provided they are a high-level employee and that non-compete is still very tailored and narrowed to what that employee is doing and how it may directly cause impact to the company. So, and then So now that would mean like maybe 5% of your employees can have a non-compete, the other 95% no longer can. So the FTC's ban did restrict non-competes in employee contracts across the board otherwise. So what does this really mean? This non-compete versus NDA. NDA, non-disclosure agreement, is restricting the movement of information, where a non-compete is restricting the movement of a person. It restricts their business and livelihood choices of that person. And this is important to know because this is how we know what we need out there. It's why non-disclosure agreements are important and completely legal to use in your B2B and your B2E, your business to employees, is because that information is yours. It's your information. It is your ideas, or it's your suppliers and your customers' information. Changing employment or changing which client you're serving and working for does not change whether or not that information needs to remain protected. Non-disclosure agreements, NDAs, are the most commonly used way to protect your information, and they are still the number one way to do so. Where they are illegal, again, is that element of if they are hiding crimes, whistleblowers, or are overly burdensome. But the non-competes is where the people are restricted themselves. So let's take a quick look at comparing both of these together right now, right? Non-disclosure, necessary for your B2B and your B2Es because they protect the information. Your information, your customers' information, your suppliers' information. Provided that you are not using them to hide crimes, whistleblower situations, and they are not overly burdensome. They are completely legal. And it's in these scenarios where the person who's trying to breach or violate your NDA might be granted an exception, or that your NDA, your non-disclosure agreement, would become invalidated as a whole. So avoid these three things at the bottom, and you want to use NDAs all the time in your business. A non-compete, we go back to the person, right? They are permitted in B2B scenarios like your freelancers and your suppliers, but they are illegal under the FTC's ban earlier this year for your business to employee context. You cannot use them in that context with those minor exceptions that we talked about for those high level employees. And it still has to be very narrowly tailored in time, location, the what type of competitors specifically, and so on. And you have to have that exact business reason, a justifiable business reason that you can say, if this happens and they went here, we are going to suffer harm. That is why we put this limitation on them. And how you get around your employees not sharing your information to the competitor is you still have that non-disclosure agreement. The non-disclosure agreement still protects the flow of that information. Just because the employee has moved to the competitor does not mean they can share the information if there is a non-disclosure agreement. The key, again, is the restriction of your information under an NDA versus the restriction and movement of a person under a non-compete. All right, so as always, we are going to give you a freebie right now. Your freebie is a free non-disclosure agreement, right? I'm, like I said, big person in about making sure all businesses have their information protected from day one. So you get a free NDA template. There's also a customization guide. You can be drafted done in under 10 minutes. And it's amazing for all your B2B scenarios. You can get that at the link there, ceolegalcoach.com/free NDA template. And then now we're going to have our live Q&A. So if you want to find the chat button on whatever platform you're on, we're streaming on multiple platforms right now, go ahead and find that. And we're going to answer a few questions here for about 5 minutes so you can all get back to your amazing work days. All right. Let's see. Can you provide examples of when non-competes might be considered overly broad or unreasonable, even if it seems necessary to protect the business? Yeah, the courts have generally found two big considerations: the amount of time, How long? Do you really need 2 years in between, or would 2 months be okay? So the amount of time, making sure that that is as tailored and as narrow as possible. And the other is geographically. It's one thing if you're living in a big city, New York, and you say, okay, you can't. Many companies nowadays are online, they're digital. So physical geographic restrictions don't need to happen. That it doesn't matter if the office is across the street. But then there's other times it does. If you're a salesperson, you go door to door, and now you're going to go to that exact same territory and now be selling the competitor's product. Well, that's a little bit different, right? So the geographical limitations and the time frame are the two most commonly considered elements by the courts. There, of course, there are others. Like I said, listing a specific product or listing a specific competitor is much better than just saying our competitors, especially if you're a big business, right? I've worked for Fortune 500s that have 5 to 7 divisions. Each of those divisions has 10 to 20 products. Okay, if I work in division 1, I can't go work for the competitor that are division 2s through 7? Or what about the products? Maybe I was only supporting 5 products in one division, but there's 15 others. So the more we can tailor and narrow it down to what is necessary and being able to articulate that necessity, the better you're to succeed. Great question. What are some best practices for drafting and implementing the combination of a non-compete and an NDA to maximize their effectiveness and minimize the risk of legal challenges? Sure. You can always keep them separate. Back in the day, back when non-competes were legal in the BDE context with your employees, the document for the non-compete and the non-disclosure were usually the same. It would usually be some form of a non-disclosure agreement with data privacy elements and a non-compete built in. It doesn't have to be a whole separate document. Where now, because it's illegal in the BDE context, except for that minor exception of higher up employees, keeping them separate, having a non-disclosure agreement that is a non-disclosure agreement, right? Non-disclosure agreements are always legal unless they're being used to hide whistleblower activities, illegal activities, crimes, and so on. So keeping that separate document separate and then having some type of non-compete addendum or having them be a separate document. That way you can only use it when you know it's okay to use it. Where if you have them together, you're constantly fighting that battle. And so I would say the best practices for drafting them and implementing them is to keep them separate. Keep them separate. They do not have to be on the same document at all. They can be 2 separate documents for sure. How do you handle a situation where the employee refuses to sign the non-disclosure agreement? So the best time to sign a non-disclosure agreement with anyone, employee, business, customer, investor, or partner, is before information is shared. Before information is shared, aka day one. Day one. I used to work for a company that once their sales team got the appointment with the potential customer, an NDA had to be signed before the first meeting was allowed to happen. So day one, the sooner the better. With an employee, that is before they start working for you. You've hired them, you've sent them the offer paper, but often the offer paper will say things like, hey, your employment is contingent on you passing a background check and other things. So they come in on day one, and now you're going to have them sign the formal employee contract. You're going to have them sign the non-disclosure agreement. And if they refuse to sign those things, guess what? They don't have an employment. So using the non-disclosure from day one, they are required to sign it in order to start the job. They can't start the job without that. And so that is how you make sure that it is done properly. Now, if they refuse, I'm a big believer that if anybody refuses to sign an NDA, one of 2 things is happening. Either this is somebody you do not want to do business with, period, in a B2B or BDE context, or they're worried about something. B2B context, still always want that NDA, but in the BDE, look, this person is not represented by an attorney. This person may not understand what they're signing. And and they want to understand it. They might have questions about it. Ask them, what is your concern? Why are you hesitating here? And see what they say. I have done it, not over a non-disclosure agreement, but I have had an offer of an employment for a promotion, everything from somebody I was already working with. And I didn't sign it. I did not accept their offer. And so I got pulled into the senior vice president's office and got sat down. Acacia, please explain to me what's going on. Why have you chosen not to accept this offer of employment right now? And I explained why. I was like, look, I have these choices ahead of me. I have the opportunity to go work somewhere else. And even though I don't know what that number is, that offer, this is what they're doing. This is how they're treating me. I also want to become a lawyer. It is my intent to go to law school. And to do that, I have to sit for the LSAT. And the day the LSAT is this year, you're saying I have to be in the office. I can't do both. I cannot be in the office and sit for the LSAT. You need to put into this contract that I'm allowed to take that day off of work right now. And if you can't give me that day off of work, well, guess what? You're making me choose between my lifelong dream of being an attorney or working here. And when I have other offers of employment, that's a very easy decision for me to make right now. Now, right? And so I wasn't going to just come out and tell them all of that, but they sat me down and asked me why. So if you have an employee who is refusing to sign an NDA, a non-disclosure agreement, ask them why. And then see if it's something that you can resolve, is worth resolving, or if it's worth walking away from. That's what I would recommend in that context, because it's also going to be good for how you're going to build your relationship with your employees. If you guys don't know, I do have my Boss from the Beach program, and that's what this whole program is about, is sometimes putting contracts and non-disclosure agreements in front of our staff, in front of our team, can come off as if we don't trust them, or start to build like a more legal wall between us and them, when success requires that we foster trustworthy, creative, open, it's okay to fail environments. And so that's what that program does, is it talks through how can we have these conversations in a way that are authentic and build the type of environment that you want in your employment structure. And so that's what I would say is you could always look at that program if that's something you're interested in. But what do you want to build into your employment structure, into your team, into your environment at work? And how does the NDA fit into that? And have that conversation with them, and then from there make a decision if you need to decide this maybe isn't the right candidate, or if you just needed to troubleshoot something. All right, one last question. Let's see. How can businesses strike a balance between protecting their confidential information and respecting the rights of their employees to pursue new opportunities? Back to that idea of understanding what it is okay to restrict the flow of your ideas, your information, what makes your business tick versus another. What is confidential to one company is not confidential to the company next door. Your direct competitor has their own definition of what is and is not confidential information. I had a client just this week ask me for the magical words, and I'm like, dude, there are no magical words. I didn't use dude, but right. It is, the law permits us to define what is and is not confidential information based on how you do business. Your business is different than your competitors. It's different than your suppliers. It's different than your customers. And you have the right to treat it differently, to be differently. So doing that, understanding that for your information, for your ideas, maybe you need to take some steps to protect them under intellectual property laws. Maybe the contracts are enough, where your employee has the right to follow their dreams, has the right to build a career of their dreams, has the right to network and build a professional group around them. They have the right to that, just as you would want a right to do that, just as I would want a right to do that. And so understanding that who they are as a person, their goals and their dreams is different than your information. They sometimes overlap, because them going off and following their dreams, going to your competitor, could come into conflict about self-interest versus trust. Self-interest for them, pursuing their goals, versus the trust they'd be violating with you. But the same goes for you. Your self-interest versus trusting your employees. Finding that right balance for you to where you're encouraging them to continue to be great, successful people out in the world, whatever their personal decisions are, provided they treat your company and your information with the respect you deserve. All right, guys, it has been Acacia, the CEO Legal Coach. Don't forget to get that free NDA template.